Welcome to Why Special Education Mediation, our workshop tonight. Deus Dedi, who is here with us, will be leading our discussion.
Thank you, Kylie. Good evening, everyone. My name is Deus Dedi Merced, and I, unfortunately, because it is a webinar, I don't get to see all of the faces that are participating today, but I will feel your wave to me as you say hello. I looked quickly at the list of participants. Some names are familiar to me, others are not so familiar. So welcome, it's nice to meet you. And hopefully one day we will be able to be in the room together and I get to shake your hand and say hello and introduce myself. As Kylie said, my name is Deus Dedi Merced. I want to tell you a little bit about my background so you understand where I'm coming from in terms of my expertise to speak about mediation. I started my career after law school. I am a licensed attorney in New York, Washington, D.C., and Massachusetts. I started my career as a disciplinary hearing officer for the New York City Department of Education. I then moved on to work with the New York City Department of Education in special education litigation. And after a number of years of doing that, I left and started working and representing parents of children with disabilities. So I've seen both sides of many disputes in special education. After a number of years of practicing, I decided that I did not want to practice as an attorney anymore. And I looked around to see where I can put my expertise, and that brought me to the District of Columbia, Washington, D.C., where I served as a hearing officer in special education disputes between parents and school districts, and ultimately was appointed after a national search to be the chief hearing officer to assist the District of Columbia in being released from court supervision, because the problems in the District of Columbia are not so dissimilar to some of the problems that folks in New York City are seeing with the impartial hearing system in New York City, to wit, one, delays in implementing hearing officer decisions, and two, delays in being seen by a hearing officer. While I serve as the chief hearing officer in the District of Columbia, I started as mediating special education disputes. I was a mediator prior to when I actually graduated from law school, and I decided that I wanted to spend some more time mediating, and I mediated quite a number of special education disputes. I did more of the heavy lifting on the mediation side. I did some of the systemic mediation between the District of Columbia and the various agencies, as well as children with disabilities. I have also served as a state review officer, and I serve as a state review officer in Nevada now. I have served as a complaint investigator in special education disputes. And my primary function now is I work with state educational agencies. Those are like the New York State Education Department around the country in helping the state educational agencies to make sure that they're complying with the federal law, the Individuals with Disabilities Education Act, IDEA for short, and making sure that they're providing the dispute resolution mechanisms that IDEA guarantees and that many states put in place. So I will run around the country from time to time speaking on special education matters. I go as far as Hawaii, and I have even trained and work with state educational agencies in some of the territories, including Puerto Rico. So that's basically my work in terms of my company, which is Special Education Solutions. The other aspect of that work is also helping the state educational agencies with systemic review and evaluation. Things don't always work as planned. Things don't always work as the law envisions it. And I'm the guy that a state educational agency can call and say, hey, help us out. fix this for us, as New York State has asked me to do on a number of occasions. The most recently in 2019, they asked me to review the New York City Impartial Hearing Office and issue a report, of which I did. So I have a lot of work in New York State, and I'm familiar with New York State, not only from the practice side as a school district attorney, but also as an attorney representing parents of children with disabilities and their children. I've been working with the state under contract for now over 10 years, and I have 2 contracts with the state. I work on the impartial hearing side, training their hearing officers, those who decide disputes between parents and school districts and special education matters, as well as training mediators who want to be special education mediators, or those who are on the list of in the state list of special education mediators, keeping up with their skills in special education law, mediation, etc. For your purposes, since we are working in a virtual environment, I want to at least explain quickly the lay of the land that's in front of me. Obviously, I'm in my office, and you see me kind of looking to the right because that's where the Zoom screen is. To the left, when I start the formal presentation, is where my materials are, and you should be seeing on your screen one of the 3 outlines that I provided to include New York City to share with you. And so you will be seeing me shifting to my left when I start to look and start presenting, because I want to follow along. I want to scroll up to make sure that you know where I am on the outline, and you'll see me from time to time that I will be highlighting on the screen so that you are able to see what I am specifically referencing on the outline. I'm looking to kind of increase the size of this so that it becomes a little easier for you to read, particularly if you're in a small screen and you're seeing both me and the materials. So my camera is on the top of my screen. So if I'm looking straight into my camera, so that's why my camera is above the screen. That's why you will never see me looking straight at you, because I'm negotiating between 2 sides of my screen, the Zoom screen and the material screens on the left. In front of me are my notes. So you will see me from time to time looking at my notes, just so that I know that I've covered the materials that I want to cover. I have my phone here, and I've asked Kylie if anything comes up along the way, there's a snafu of some kind, of which I don't anticipate any, if she needs to text me something that requires my immediate attention, that she can do so. So if you do see me look down quickly at my phone, it's not because I'm making dinner plans with my best friends, or thinking about next week. It's because I'm dealing with something with Kylie on the production and on the back end. As Kylie suggested, I do encourage questions, and I hope that, one, you will have an opportunity to put questions in the Q&A dialog box in Zoom. But towards the end, when I end the formal presentation, I've asked Kylie that not only will I be happy to go through the Q&A, but I will invite folks to ask their questions directly of me, and she will, if you raise your hand in Zoom, she will unmute you and you can ask the question directly of me. During the presentation, Kylie is going to be kind of sorting through the Q&A and looking at whether there's a question that she should be asking me at the moment, and I invite her to do that because I'd rather answer the question as we're talking about the topic. Do not be discouraged if I am talking faster than you can type your questions in the Q&A. Finish the question. Do not erase it because you think I've moved on and you don't really want to ask the question. Just put it in there and Kylie will sort through it. And certainly I can go back to those questions at the end. And if I need clarification, I will ask the individual who posted the question to raise their hand so Kylie can unmute you so that we can engage directly as opposed to through the dialogue box. As I indicated, I provided you with 3 documents. The first document is the resolving disputes under IDEA. And I'm going to use that as a foundation for leading up to the discussion as to why mediation, why special mediation over due process or state complaint. Those two I will explain as well when I start. But I wanted to highlight two other documents that I think might be of value to you, particularly as parents, as practitioners in this field. The first is the IDEA, the basics, the Individuals with Disabilities Education Act, the basics. As you know, the foundation of all special education rights for children with disabilities who are eligible or suspected of having a disability is the IDEA, a federal law that requires school districts who take federal monies to educate all children with disabilities and provide them with a free, appropriate public education if they're eligible under IDEA. So what I do in this outline, which is 39 pages, is I outline for you in a very basic way what the regulations and the statute says. This is the regulations. I carry this around wherever I go. But if we were to read this from cover to cover, from page 1 to whatever number of pages there are, it doesn't make much sense. So what I try to do is distill the essential components of the IDEA. And if you read this through, you'll get a better sense than reading this cover to cover of what IDEA requires in terms of educating children with disabilities who are eligible under IDEA. The third document that I provided to you is what I call the IP building blocks. Many of you have been at IP meetings. Some of you have participated as school district members of the Committee on Special Education, which is the term used in New York State for the IEP team, the Committee on Special Education or the Committee on Preschool Special Education. And there's a process that has to be followed. You've seen the documents, perhaps if you have a child with a disability. And as I explained to folks, the IEP is the essential component where for educating children with disabilities, but where most disagreements happened often between school districts and parents. It's a layered document, meaning that it builds from a foundation, which we call the present levels of academic achievement and functional performance, which is all the information you know, what you've reported to the school district, the evaluation data, all those numbers that they give you on the testing and all that you've reported about the strengths of your child, where you would like your child to be, the weaknesses, how your child best learns, etc. All of that is in the IEP, and we build from that information into annual goals, into services, into other aspects of the IEP, and ultimately placement, the general environment in which the IEP is going to be implemented. So this document takes that in the most reasonable way that IDEA anticipates a Committee on Special Education, an IEP team, is supposed to attack creating an IEP for a student who is eligible under IDEA. If you were, again, looking at the regulations, looking at the statute, you would not have a sense of what's supposed to happen, what should the Committee on Special Education, the CSE, should be talking about first. So again, we take the information and we try to break it down in a manner that is, one, accessible to you folks, something that you understand, taking out all the legalese out of it as much as we can, and we explain it to you, and it's sequentially as how the IEP team should be, the IEP should be built. So I hope those two documents are helpful to you. I'm going to start with resolving disputes under IDEA. I can't convince you why mediation is better than the other dispute resolution mechanisms if I don't provide you with a foundation as to what the other two mechanisms are and what IDEA says regarding mediation, how mediation is supposed to work under IDEA. So I want to spend some time making notes about the difference between due process, state complaints, and mediation. First, as I just suggested to you, under the federal law, the IDEA, Individuals with Disabilities Education Act, some of you might have heard it as the IDEIA, the Individuals with Disabilities Education Improvement Act. IDEA was amended in 2004, and they changed the name to add the word improvement into it, but you still can call it IDEA. So that's my preferred term. So I rather use the term IDEA. Children with disabilities under the IDEA are entitled to a free, appropriate public education. And those rights are spelled out not only in the federal law, but also New York State is responsible for putting in place laws, practices, and policies that provide equal rights to what the federal law guarantees, or even more rights than what the federal laws guarantee. New York State cannot take away rights that the federal law requires. If you're going to take the federal monies, the IDEA says, you have to provide a framework that at a minimum provides what we require of you under the federal law. And IDEA, as I just suggested, does provide monies to states to help in educating children with disabilities. Last I checked, New York State, for example, gets about $900 million per year to help educate children with disabilities. That number, while it might sound huge and might be even better in our bank accounts, the truth of the matter is $900 million falls quite short of educating children with disabilities in New York State. But if you take that money from the federal government, the state is required to supplement it with its own money in order to address all of the needs of children with disabilities residing in New York State. So let's talk about the 3 dispute resolution mechanisms. The first that I want to tackle, because it's the one that is the most involved under IDEA, is due process complaints. Some of you may have had experiences in filing a due process complaint against the New York City Department of Education. If there is a dispute between the school district, one of the options that you have is to file a formal complaint against the school district, here, the New York City Department of Education. I'm presuming that most folks on this call, given that it is include New York City, are from the New York City Department of Education local educational agency. What can be heard in a due process complaint comes down to 4 matters. What in the legal world is called that subject matter. What's the subject that the judge who will be presiding in a due process hearing is able to hear? And under IDEA and New York State law, that judge is referred to as a hearing officer or an impartial hearing officer. And the 4 subject matters that can be heard can be found right here in paragraph A1. The first, it has to do with the identification. The second is evaluation or the educational placement of a child with a disability, or the provision of a free, appropriate public education. When we talk about identification and we talk about evaluation, what we're talking about is that under IDEA, every state, every local school district, the New York City Department of Education, has an affirmative obligation to go out and identify not only children who have disabilities, but children who are suspected of having a disability. And once they identify these children, we are tasked as a school district with evaluating that child to in fact determine whether the child is eligible under IDEA. And eligibility under IDEA requires that the school district go through 4 steps. The first step is evaluate. And by evaluation, it goes beyond just simple testing. It's engaging with parents, is getting information from parents, looking at perhaps classwork, other materials, other data that's available to the school district, maybe standardized tests, any information that the parent shared from a doctor or a clinician or someone who's working with the student outside of the school district, as well as formal testing that the school district itself conducts through the Committee on Special Education. And once we identify and we evaluate, the next thing in terms of determining eligibility is that we need to categorize what disability this child has. And IDEA spells out 13 disabilities. I'm not going to go into the 13 because it's really not necessary for the purposes of the discussion. However, if you want to know what those 13 disabilities are, you will find that in that IDEA basics outline. That's where I spell all that out for you. And once they kind of place the child in one of those 13s, the next thing that the school district has to determine is whether, because of that disability, the student is adversely affected regarding educational performance. So there has to be some limitations that's happening as a result of the disability. There has to be some harm that's happening if we do not alleviate that disability by providing services in the school district. And it has to be regarding educational performance. Educational performance is not necessarily the equivalent of academic performance. Educational performance is a little more, it's broader than academic performance. We want to see how the students impacted academically, right? It is school, but it might go beyond that. For example, daily living skills. Is my child able to negotiate, walking in the streets? If my child able to address certain things like basic hygiene, things that are typically a typically developing peer might be able to do, we don't take for granted in IDEA. We want to know whether the child with a disability is impacted beyond academics. And if we agree that it is, then we need to determine whether the student requires special education and related services. And if so, we want to meet those needs. So that's one of the subject matters that we address. It's the eligibility, and that comes down under that subject matter of free, appropriate public education. Once we created that layered document, the IEP, we need to decide where are we going to implement this IEP. And I'm not talking about PS5, IS 184, or John Doe High School. What we're talking about when we're talking about placement under IDEA is the general type of environment. Do I have a child who can be successful in general education if we provide support services? Do I have a child who requires a little bit more, perhaps being pulled out of the general education environment and working one-on-one on a small group with a, for example, resource room teacher? Does my child require related services? And again, could that be provided in the classroom, in the general education classroom, or on a pull-out basis? Does my kid require a smaller class, perhaps of all children with disabilities, and one teacher and maybe a maximum of 15 kids, 12 kids, 8 kids, 6 kids in the classroom with some additional adult support? Does my child require a non-public school placement, a private day program, or does my child require residential? And that's what we start to look at when we start talking about placement under IDEA. IDEA has 2 types of potential hearings. They're non-discipline cases, of which I just explained to you the subject matter. And then there are disciplinary cases. And I'm going to hold off on describing the subject matter for the disciplinary cases until the end after I've covered the non-discipline cases. And you will see, and this is why you have it on writing, that there's a lot of details in IDA, and I'm going to do my best to try to make it as clear as I can, but you will probably pick up on this and say, wow, there's a lot of detail here. But fortunately for you, you have the outlines. And I believe Kylie, if you can't find yours, Kylie put the outlines up in the chat feature. You can click on those outlines and they will download to your computer so you have them readily available if you need them. There is a time limitation when you can file a complaint against a school district, or the school district can file a complaint against a parent. And there are times when a school district can file a complaint against a parent. I'm not going to worry about that at this point. But that time limitation is 2 years. And that's 2 years from the moment that you knew, or there would have been reason for you to know, that there's some kind of violation that is inconsistent with what IDEA requires or even New York state law. And you have 2 years from when you learn about it, or you should have learned about it, in order to file that due process complaint. Looking at my notes to make sure I cover what I want to cover in terms of the points I'm making. And are there exceptions to that? What if I miss those 2 years? Are there exceptions to? There are exceptions to that. Highly, a little bit more technical than we need to be for purposes of, again, differentiating due process from mediation, but it's listed. It's listed here in page 2. And I'm highlighting that. There are 2 exceptions to failure to meet the statute of limitations. In 2004, because of the number of due process complaints, Congress said, you know what, folks, before you march into court, we would like to give the parent and a school district an opportunity to try to resolve their complaints. This is an opportunity for the parent and an individual from the school district who has the ability to agree to whatever it is that is agreed upon in this meeting, to require the school district to then follow through with what is agreed to in writing. And they can sign on behalf of the school district this agreement that is required if there is an agreement. And that happens in what is called a resolution meeting. And there's specific timeline by when that meeting has to take place once you file the due process complaint. That timeline, again, not getting into the nitty-gritty of this, but just to give you a sense of how quickly this goes through, is 15 calendar days from the date that the school district receives the due process complaint. The school district does not have the option to push that off, by, more days than 15 calendar days. They're required to conduct the meeting within 15 calendar days of a parent providing the school district with a copy of the complaint. And as I suggested, there has to be someone in that meeting that has decision-making authority. We don't want to talk about what might be, or let me go get some authority to agree to this. I need to talk to my boss. What the person that has to be in the room from the school district is someone who can agree to what it's being offered and discussed during this resolution meeting. The parties, if they need more time, they can have more time under IDEA, and IDEA says, hey, we will give you a total of 30 days from the date that the parent, for example, files a due process complaint. But that meeting does have to take place within the first 15 calendar days. And if you need more time, you'll be given essentially an additional 30 days, an additional 15 days to try to resolve it. And that happens from time to time. Now, IDEA says, hey, listen, parent and school district, you can meet, and you can meet in this meeting, and you cannot go into a formal hearing until this meeting takes place. And there are exceptions to that. right? There's exceptions to whether we can jumpstart the meeting, whether we do go to meeting, we don't reach agreement, to start the timeline for the hearing. There are exceptions to that. I'm not going to get into all of that, but IDA also recognizes that the resolution meeting has one major flaw. And the major flaw is that this meeting is between the parent and the school district, and they must speak to each other directly without the benefit of a third-party neutral who can help facilitate the discussion. And so IDA says, hey, in lieu of this meeting, if you choose not to participate in this meeting and you prefer to have a third-party neutral, someone who can help with the discussions, who can help the parties communicate their ideas, their thoughts, you can choose to have mediation instead. And so IDA envisions that if the parties prefer to have the assistance of a third-party neutral, then we can bypass this resolution meeting and the parties can choose to have mediation instead. And I'm going to talk about mediation, and I'm going to talk about some of the limitations of mediation, as well as the limitations of the resolution meeting as I move on through the materials. The goal of the resolution meeting is, at the end of the day, to reach a written agreement. An agreement that under IDEA has to be enforceable in a court of law. You should be able, if you reached an agreement and the person who has the decision-making authority sign on the dotted line, the proverbial dotted line, you should be able to take this agreement if the school district does not do something and file in a court of law and require the school district, for example, to, if they're the ones who are not complying, to do whatever it is that it was agreed upon. Now, going into court is not inexpensive. And so IDA also envisions that there is another mechanism to enforce the agreements that are reached in the resolution meeting, and that's called a state complaint, of which I'm going to talk about once I finish discussing due process. Who participates in that resolution meeting other than the parent and this decision-making individual from the school district? Well, there could be people from the Committee on Special Education who can assist in coming up with an agreement. It could be other individuals that the parent invites, as well as the school district. The school district under IDEA cannot have an attorney in that meeting unless the parent is accompanied by an attorney. So whether an attorney is in the room is driven by whether the parent also invites an attorney. Otherwise, the school district cannot have an attorney in the room. And the whole idea behind this, we're not looking, if that's what possibly the hearing is for. We're not looking to make this more acrimonious, more difficult than it is. The whole idea of this is, hey, one last shot before you go before the judge. Can you try to resolve your differences? And as I said, if there is agreement, it has to be in writing. It has to be binding, meaning that's enforceable in through the state complaint process or a court, and both parties have to sign it. Now, under IDEA says, sometimes we agree to things, but maybe we agree to it in haste, or maybe we did not cover everything that we should have covered the agreement. And so IDEA says that either party, the parent, school district, once they sign the agreement, they can pull out of that agreement by requesting that the agreement be voided within 3 business days from the date that the agreement was signed between the school district and the parent. So there, if you change your mind, you go back home, you thought about it, says, you know what, I don't think this is the best agreement. I was hesitant then during the resolution. I don't think this is the best agreement. I'm going to send a written notice to the school district that I do not want to have this agreement in place. And so long as you do that within 3 business days, then the agreement is voided. If you do not do that within the 3 business days, then the agreement becomes enforceable both for the parent and the school district. The school district can enforce what was agreed upon, and so would the parent be able to enforce what's required of the school district in there. And we
We
talked
have a
about,
quick question regarding this particular one, if that's okay.
yeah, go ahead.
Okay, it says, can you please give some explanation regarding the ability to void such an agreement within 3 business days in a resolution meeting, but why does this not apply to mediation?
That's a really good question. And I don't have an answer as to why it doesn't apply to mediation. Now, there's nothing to say that the parties cannot agree in a mediation to have the same provision included in the mediated agreement. But it would be something that the parties would have to agree as part of the mediation and put that on the table when they meet with a mediator and say, listen, I would like the opportunity to have some time after the mediation agreement to decide that even though I signed this agreement, that I have had a change of heart, a change of mind on that. So there's nothing to say that you can't do it, but it would be something that would need to be negotiated between the school district and the parent and made expressly part of the agreement. I believe that in terms of mediation in this country, the idea is that the parties with the benefit of this third party neutral, that they really thought through what it is that they want to agree upon, that they've had an opportunity to share their thoughts, their ideas, etc. And therefore there would not be a need to avoid the agreement after the fact, because you had that third party there to kind of preserve the integrity of the process, to talk and make sure that everyone has had an opportunity to share their ideas, their thoughts, to ask questions, to make sure that everyone understands what's happening and what's being agreed upon, to make sure that the parties are talking about the specific words in the agreement so that there's no confusion there. So I think IDA made the Congress who wrote the IDA made a conscientious decision consistent with the practice of mediation in other areas of the law that that is not required. You don't have the benefit of that third party neutral in a resolution meeting. So there may be instances in which something that is agreed upon after further consideration, maybe counsel from a family member, maybe talking to a lawyer, an educational advocate, talking to a friend who does education and might have a better understanding of what was agreed upon. They might talk to the parent or the school district, say, hey, maybe, this is not in your best interest. So I think the absence of that third party neutral perhaps makes that one of the primary reasons why this, opportunity to pull out, where was it? To leave, to notify the school district within 3 business days that you no longer want that agreement in place. Thank you for the question. Now, once this resolution period is over, if the parties do not reach an agreement, then we have no choice, if we file the due process complaint, to go move forward with the actual hearing. In IDA, a hearing is a much more formal process than you will see in mediation. And when we start talking about mediation, it is probably closer to what you probably have become accustomed, if you've never been in a hearing, to something that looks like a court proceeding. Sometimes you have lawyers involved representing either side. You have a judge who's called a hearing officer, and he or she is there to preside over the hearing, and he or she is going to make a decision one way or the other as to who's right, who's wrong. Maybe both sides are wrong, but nonetheless, a remedy is required, or hey, I think you're right, but what you're asking is not it's not supported by the record, by the evidence that you presented, and therefore I'm going to remedy it, but not give you what you're asking for, but give you a different award. Well, all of that has to happen under IDA within 45 calendar days from the end of the resolution period. The idea here under IDA is, for children with disabilities, we don't want to wait too long to come up with a decision. Most children are in school for 180 school days. And if we allow this to prolong for years, then what we're doing is, if a child's not getting appropriate services, is we're compounding the problem, right? So IDA is very strict about timelines. Once you complete the resolution period, we want to make sure that the hearing officer renders a decision, makes his or her decision regarding the issues that are before him or her, and let the parties know who's right, who's wrong, what the remedy is. For some, the parent might file and not prevail, and the school district and the hearing officer might find that whatever the school district offered was appropriate to provide a free, appropriate education to the child. And in other instances, the hearing officer might say, hey, the parent is right, and the parent, whatever the parent's asking for, is an appropriate remedy, and I'm going to award that remedy. But that all has to happen within 45 calendar days. The hearing officer has to hear the matter. The hearing officer has to render his or her decision. The hearing officer can extend that timeline. They can say, we need more than 45 calendar days to finish this hearing. But the hearing officer cannot do that on his or her own. He can say, hey, I'm on vacation during this time, and why don't we do this 3 months from now? They cannot do that. The hearing officer can extend the timeline and has the authority to extend the timeline, but that is at the request of one or both parties. And on the New York state law, the hearing officer has to consider a number of things before he or she says, yes, I agree that an extension is appropriate in these circumstances in order to allow for the parties to do whatever it is as the basis of why they requested the extension. Let me give you an example. The parties, perhaps they did not agree during the resolution period, but maybe they, after some thought, after considering some more information, they decide they want to settle the case. They don't want to litigate. They don't want to roll the dice, so to speak, in front of a judge, and they agree to reach an agreement. And therefore, they're working to get that agreement completed, finished, written out, etc. That might be a reason why more time might be needed. Others is because, for example, the student might be undergoing additional assessments, an evaluation, so to speak, and more time is needed to complete it. Or the parties are agreeing to return to Committee on Special Education meeting to look at some additional information or whatever it is, and they want more time because that might change the need for a hearing. So there are many reasons why the hearing officer can extend the timeline. But the bottom line is that IDEA has a preference to completing these types of cases quickly, and they have defined quickly as 45 calendar days from the end of the resolution period. Note, however, that if the school district initiates the complaint, there's no resolution meeting required. And there's a huge assumption, and that's what it is under IDEA, but it is what it is. It's what IDEA says, that a school district would not need to sit down with the parent again to try to resolve their differences, because they would have done that in the first place before feeling like they needed to file a due process complaint. So if the school district initiates a due process complaint, then the 45 calendar days start from the day that the parent receives the complaint. And that is the non-discipline timelines. Let's talk about discipline. Let's talk about discipline. I said to you that discipline is governed by different rules. Well, the first one is, well, what's the subject matter? The subject matter of non-discipline cases, if you remember, is identification, evaluation, provision of FAPE, and placement. The discipline cases are cases in which the student is removed from the placement that he or she is customarily in through the IEP, and the parent says, wait a minute, you shouldn't have moved my kid from here. This is not right. And therefore they want to challenge that removal. The second is when a child who is eligible under IDEA breaks the code of conduct in a school, they may be disciplined under certain circumstances. And if they are disciplined and they're being removed from school, or they're asking to remove the kid from school for more than 10 school days, IDEA says, wait a minute, let's make sure that we're not punishing the child simply because of his or her disability. If the misconduct happened as a result of, was caused by a direct result of the child's disability, well, it's not fair to discipline the kid if that is the reason why the kid had this misconduct that led to this suspension, is because it's part of the disability. So we're not going to punish the kid for having a disability, and we're going to decide whether it is a what is called a manifestation of the student's disability and what is called a manifestation determination review meeting, an MDR, manifestation determination review meeting. And if that meeting, the school district sees it differently to the parent, and the parent disagrees with the outcome of that meeting, the parent has the right to challenge the decision that is made, and that would be a disciplinary hearing. The third instance in which you might have a disciplinary hearing is where the school district initiates the complaint and is looking to remove the student from their placement and place the student in a different location in an interim placement up to 45 school days, because the student is viewed by the school district as someone who is substantially likely to injure himself or herself or others. Well, they can't just willy-nilly just pull the kid out of the class and say, hey, go home for 30 days because you might cause an injury to others or you're hurting yourself, and we don't want to be bothered by that. The school district has to initiate a due process complaint to ask a hearing officer to remove the student from that. Either of those three subject matters, the three I just covered, you're entitled to what's called an expedited hearing. And an expedited hearing means that the hearing itself has to happen within 20 school days from receipt of the complaint, and the hearing officer must also render their decision quickly, and that has to be within 10 school days of the last day of hearing. So 20 school days, we've got to wrap it all up in terms of the hearing, and the decision as to who's right, who's wrong, and what has to happen from the hearing officer must be issued within 10 school days. We do have a resolution period under a expedited due process hearing, a disciplinary hearing. The difference is, instead of the meeting happening within 15 calendar days and the parties having a total of 30 calendar days to resolve their differences, it is now 7 calendar days to meet and 15 calendar days total to try to resolve their differences. In IDEA, someone has to convince the judge that he or she is right. And typically in IDEA, that falls on the party who is filing the due process complaint. So in the typical instance, the parent, if they believe that their child was denied appropriate education and they file due process complaint, they have to convince the judge that the school district is not providing appropriate services. That typical instance does not happen in New York. In New York, the New York legislature said, whether the parent files the due process complaint or not, we're not going to worry about putting the burden on the parent to prove that they're right. We're going to require the school district to prove that they received a free, appropriate public education. And there's one exception to that where the parent might carry some of the burden, and that's in the reimbursement cases, the tuition reimbursement cases, of which I'm not going to talk about right now. But what I wanted to emphasize is to who persuades the judge that he or she's right. Well, in New York State has said that even if the parent files, the school district must prove to the judge that they offered the student a free, appropriate public education, and the parent does not have the initial burden to have to do that. IDEA also says under the hearing process that we want to make sure that all claims that are before are decided not because the school district forgot to dot their I's, cross their T's, but that there is some substantive harm to the child. And so while there may be things that the school district did not do in evaluating the child and identifying the child and coming up with the IEP in the CSE meeting, that does not necessarily mean that if you point those out that you can win a due process hearing. IDEA says, hey, listen, it has to really impact the student's right to a free, appropriate public education. There has to be some substantive harm. The parent has to be significantly impeded from being able to participate in making decisions about the student, or there has to be some deprivation of benefits, educational benefits to the student. And that in a nutshell is due process. And I'm going to put all this together to why I think mediation in a bit. And you'll see that the other two processes are not as long as due process. Due process is what you probably have seen on television and Matlock. I might be dating myself, whatever, program is out there that where you see civil litigation and lawyers going, after each other, et cetera. Due process, unfortunately, has become that. Now, IDEA says, hey, listen, it doesn't always have to be so acrimonious. A parent or a school district can choose to file a complaint about anything that they could have filed in due process. And they file that with the state educational agency, the New York State Department of Education in New York. And the state must then investigate, and it's an more informal process. They must investigate whether, in fact, whatever's alleged in the complaint is true or not. And they do so by asking for information, either by talking to the parent, talking to individuals that the parent would like the investigator to talk to, talking to the school district, and asking for information from the school district. And the state complaint investigator, they can do the same thing as a hearing officer can do in terms of they can remedy, they can provide awards, they can address these failures to provide appropriate education in the same way that a hearing officer can, but they could do one more thing than a hearing officer cannot do. If they learn while while working on a state complaint, your case, for example, you file a state complaint that, hey, your little Johnny is not the only kid who is not getting appropriate education. Something's happening in that school district that is not consistent with IDEA. They can require the school district to correct what they're not doing right, even though only Johnny's parents filed a due process complaint. They can expand it and say, if Johnny is being impacted and because they're not doing what they're supposed to be doing, they're not trained properly, we can require the school district to fix it for all the little Johnnies out there, not just the Johnny that's in front of me. You can mediate state complaints too. And as we'll talk about mediation, before the investigator starts the process, you can ask to mediate the state complaint and see if you can resolve the differences. Unlike a due process complaint where you have up to 2 years to file your complaint, a state complaint has a 1 year, what we call in law, a statute of limitations. So you have 1 year from when the parent learns of a potential violation or should have learned of that potential violation to file the complaint with the state. The complaint investigator is given 60 calendar days to investigate and to render the decision. That can be extended. That doesn't happen as often as in due process, but it can be extended if the circumstances warrant an extension of the timeline. Let's talk about mediation. And you will see, if you're looking at your outline, that there's not much here. And that's because IDEA doesn't include a heck of a lot under mediation. And so let me tell you what IDEA says, and then we can get into why mediation is better. It is the third option that's available to the parties who reach impasse or disagreement about an issue. It has to be available to the parties at any time. You don't have to file a due process complaint to say, okay, now I can ask for mediation. You don't have to file a state complaint to ask for mediation. If something is not going right, whether it's at the Committee on Special Education, you start off and you're even disagreeing on how to spell your kid's name, you can ask for mediation right at that moment. You can ask for mediation when there's something going wrong in the classroom. IDEA is quite expansive as to when mediation is available. And so mediation under federal and state law is it must be available to the parties at any time. Now, with mediation, both parties have to agree to mediate. If one party wants to mediate and the other party does not want to mediate, the school district doesn't want to mediate, but the parent wants to mediate, then mediation cannot move forward. So both parties have to be willing to come to the table and work with a third party neutral to try to resolve their differences. Now, who's the mediator? Well, a mediator has to be someone who is trained in effective mediation techniques. And by that, they're talking about, hey, they can facilitate discussions, they listen attentively, they can help the parties come up with solutions to the problems. They're specifically trained in most programs. In order to become a mediator, you are at a minimum spending to just start 30 to 40 hours in training to become a mediator. Now, if you want to become a special education mediator, not only do you need that initial training of 30 to 40 hours, you need additional training to learn about special education law and special education matters. So a special education mediator is not just someone who's trained to mediate any types of dispute. Under IDEA, they're required to have more specialized training, and they have to train in special education law and practices, which brings me to the point where I want to indicate how mediation happens in New York State. First, unlike any other state, New York State has said that all mediations must go through what is known as a community dispute resolution center. And there are 20 CDRCs, community dispute resolution centers, throughout the state. And these CDRCs are associated with various school districts, various counties in New York State. And my recollection, and please don't quote me, and some of you from the CDRCs that are on the line, please correct me on the chat if I'm wrong. I believe in New York City there are 4 CDRCs. I'm just trying to decide whether they're 4 or 5, but help me out if my recollection is not correct. But New York City has a lot of CDRCs, more so than some other places. And the CDRCs are responsible for identifying volunteers who were trained not only in effective mediation techniques, communication, facilitation, etc., but also who are willing to be trained in effective in special education law. And it is the New York State Department of Education's primary responsibility to train these mediators. And that's where I come in, and my company is the source of that training. And so every fall, we train mediators who want to mediate in special education and want to be added to the list of special education mediators. And so we train those folks, and they have to undergo a 2-day training in which we provide a lot of information. Some of the information, like the information I just shared with you, some of the information like the basics of IDEA, like they have to understand the foundation of how IDEA works. Some of it has to do with, well, how do IEPs work? How do you create an IEP? What does the Committee on Special Education have to do? That's the kind of training they get over 2 days. And some CDRCs, like the ones that are in New York City, they do additional training beyond what the New York State requires. And to me, that's fantastic. The more training you have, the better it is. And some CDRCs have individuals, and I know for a fact that New York City, at least one CDRC that comes to mind, have individuals who have a lot of experience in special education, and they become a resource for the mediators in continuing their education and learning about special education. Neither my company, the CDRCs, the Community Dispute Resolution Meetings, the volunteers who serve as special education mediators are employees of the New York State Department of Education or the local school district. These are independent individuals. I'm an independent provider. I am under contract with the state, but I don't work for the state in that I have to check in at 9 and I leave at 5 and I get 3 weeks vacation, yada, yada. What I say, the content of what I share, these types of trainings, I don't have the New York State Education Department scripting me and putting on my nose, say, we want you to say this to the mediators. We want you to say this to the hearing officer. That doesn't happen. Same is true with the CDRCs as well as the mediators. They're independent. They don't work for the school district. They don't work for the State Education Department, because the law says they must be impartial.
Oh, you were right on the 4 CDRCs.
My memory is still good. Thank you so much for that. I'm just reviewing my notes to make sure I cover what I wanted to cover. There is yearly training that's offered by us, Special Education Solutions, to the mediators, including the veteran mediators. For those who are already special education mediators, every year we offer a one-day training, and we offer from time to time information, new outlines, for example, new information that can help develop their expertise in special education. Because at the end of the day, you don't want to sit with someone who doesn't understand special education law, right? You want to feel comfortable that they are able to assist you in the dispute that you're having with the school district. Mediation has to happen in a timely manner, and it has to be held in a location that's convenient to the parties in the dispute. Those discussions during a mediation are confidential. This gives me an opportunity to distinguish between mediation and a resolution meeting, that meeting that happens only between the school district and the parent prior to walking into a due process hearing. And what IDA says is, hey, we want to promote candid discussions. We want you in a mediation to, if you're going to propose something, that you can propose it and not worry that it can be raised later in a due process complaint. And many parents, often what we hear, not just in New York State, but around the country is, can I trust that what I'm saying and what I'm sharing here is not going to show up is not going to come up in a due process hearing later, because I shared it during the mediation. And IDA says, no, those discussions cannot be raised in what they call a subsequent proceeding, whether it's an informal hearing under IDA or some state or federal court proceeding. So conversations in mediation are confidential. The same is not true in a resolution meeting. What you say in a resolution meeting can be raised if the hearing officer allows it, and the hearing officer thinks, hey, I think this will be helpful for me to hear what happened at the resolution meeting in rendering my decision. They can allow those discussions to come in. The same is not true in the mediation context. The parties can reach an agreement, and that agreement has to be enforceable, again, either through the state complaint process or in a court of law. Mediation can address the same subject matters as in a discipline case or a non-discipline case. Remember, there was 4 for non-discipline, 3 for discipline. But better yet, mediation can also be used to address any other matters arising under the special education laws that are not subject to due process. What do I mean? A hearing officer, if you don't like the classroom teacher, or the classroom teacher is not treating little Johnny right, and you want to shift the Johnny out of Dr. Jones' class or Dr. Doe's class, you cannot go to a hearing officer and say, hey, I don't like that teacher. I want to move, I want to move Johnny out of that little class because it's not working, that she or he's not implementing the IEP. Mediation, you can raise that. And if the parties agree to remove Johnny from Dr. Jones' class, they can agree to put him or her in Dr. Doe's class. They can also agree to change the school. They can agree to do other things that a hearing officer, a judge in a due process hearing cannot do. There are some limitations that I list here under that New York State imposes in the mediation context. Some of them I'm not going to get into because they're hyper technical, but what I do want to point out is these first two. One is that, as you know, in New York City, there's what's called a subcommittee of the Committee on Special Education. Well, New York State says, well, if you have a dispute in the subcommittee, you must first go to the Committee on Special Education before you can mediate. You also can't, if you hire a lawyer, you can't mediate fees. The fees cannot be part of the agreement. What I want to point out here is that these two provisions of the 5 that I have listed here are under reconsideration at our request of New York State. If you have a disagreement in a subcommittee, we don't want the parties to go to yet another meeting where it could become even a larger disagreement. We want the parties to have the benefit to be able to speak to a third party neutral to see if they can resolve their dispute. So that's being reconsidered. And if you have an attorney and you owe the attorney fees and you're still going to be on the hook, mediation is going to be a lot cheaper than litigating a case. So we have asked the state to reconsider the prohibition of including fees in a mediated agreement, and they are considering that. So with that, I'm going to go through my why mediation first. And you will see that I'm going to go through the list fairly quickly because they're pretty straightforward. You have the background now, some of which I've already pointed out. First, mediation is not to the exclusion of any other processes. If you go to due process, you can still mediate. If you go to a resolution meeting and things don't work out, you can always ask to mediate as well. State complaint, the same thing. A mediation is always available to you. Unlike a due process, mediation is not a legal proceeding. You're not sitting in front of a judge. The process empowers the school district, the parent, to resolve their own conflicts with the benefit of someone who is highly skilled in resolving conflicts, the mediator. You don't need an attorney to be in the room to mediate. You can work with the school district directly. The difference between that and the resolution meeting is that the mediator is there to make sure to preserve the process, make sure that everyone is being respectful of each other, everyone is listening to themselves, and at times to make sure that what is being said is accurate. So you don't need to pay for a lawyer or an educational advocate to come in and assist you in the mediation. Now, if you do want an attorney, if you want an education, they can come in too, and they can participate in the process. Even though the parties have spent maybe countless hours in a Committee on Special Education meeting and they haven't come up with a solution, With mediation, you have a mediator who can help you come up with new ideas. This is why they're specifically trained in special education law, etc. And we spend a lot of time, particularly with the veteran special education mediators, in coming up with different scenarios that come up and say, hey, let's collaborate. If this happens, what might you consider suggesting to the parties? What have you done in prior instances of this that helps the parties find a resolution to their conflict? So you have someone who has the benefit of being able to assist with new ideas, of looking at the conflict and kind of stepping back and say, hey, have you thought about this? And sometimes, more often than not, that is quite helpful in resolving the dispute. It is highly successful. Unlike me on a hearing where someone's going to lose and someone's going to win, of the mediations that are reviewed in New York State, at least 86% of those mediations have resulted in an agreement. 86% of those mediations, there is an agreement. Folks are not walking out of there feeling like they lost. They have an agreement, they resolved their differences. Mediation is flexible. You come up with the solution. You work with the third party neutral to come up with ideas that correct whatever is going wrong. Not necessarily so in a state complaint and a due process. Like I said, in a due process, there's a judge who's deciding. Sometimes you win and sometimes you win what you're asking for. Other times you win, but you don't get what you're asking for. The same thing in the state complaint. In a mediation, if both parties agree to what's being asked for, maybe with some modifications, some tweaking here or there, you created your own solution. You did not roll the dice and let some party, some other person who doesn't really know your child, come up with a solution. Mediation allows for differences in culture and language to be woven into the process. Obviously, you can, as we're having here and include New York City webinar, there will be interpreters in there. If there are cultural differences that need to be accommodated in the process, that can happen as well with the assistance of the mediator. It is a cooperative process than due process or written state complaints. We are cooperating with each other. It allows for creative solutions than the other processes. As a judge, I can't just kind of pull out of a hat something that I say, oh, this is a good idea. No, it has to be supported by the record and it has to be consistent with IGA. There's no such limitation in mediation. The limitation is based on either party agreeing to what is being discussed. The solutions are implemented because the agreement is enforceable. Just like a decision of a hearing officer is enforceable in a court of law, in state complaint, a mediation agreement is enforceable. It's not like you're walking out with a piece of paper that says, yeah, the school district might want to do that, should do this. It's an enforceable agreement. This is what the school district will do, and they have to do it by this date. It is free. It is free, and let me tell you, it is faster than a due process hearing and state complaint. Most mediations occur within a week to 2 weeks from the request being made. That's fast. And as some of you who might have been are acquainted with the process in New York City regarding due process, there are kids who have been sitting on a wait list waiting to see a judge for over a year or close to a year. That's not fast. That's not helping that child. the reports are that most people who participate in mediation feel satisfied, feel like they're walking away with a solution that they help come up with, and they feel satisfied that that solution will in fact help the student. It is confidential. Mediation is confidential. We cannot bring those discussions into the due process hearing or state complaint. In a resolution meeting, you reach an agreement and you can back out within those 3 business days. Not so in a mediated agreement. If you're a parent and you think you've got a great agreement, you don't need to back out of that. And the school district can't back out of that. As in my response to the question, can that be included in a mediated agreement? Yes, it can be included, but both parties have to agree to do that. It can't just be one person say, I insist that that be included in the agreement. That's not mediating an agreement. That's not reaching agreement on what should be included in the mediated agreement. As I said, 1 week to 2 weeks for hearings, for the mediation to be completed. In discipline cases, that timeline can even be longer than in a hearing, particularly if the kid gets into trouble right before a break. We don't have to worry about that in mediation, because as soon as the request for mediation comes in and the parties agree to mediate within 1 to 2 weeks, we will at least have an understanding as to whether an agreement is reached. Mediation is not about who is right or wrong. That's what due process and state complaints. Someone's wrong, someone's going to lose. Not so with the mediation. It's not about finding fault and placing blame, but about reaching an agreement that matters, and that matters to the only person who's important in that discussion, that child with a disability. In mediation, how you move forward is up to you. What is best for the student. In due process and state complaints, you surrender that decision to the judge, to the investigator, who is not as familiar with the student. Mediation helps to repair the relationship between school districts and parents. I say this often, and I've litigated cases on both sides, and I say this to the judges who I train and to the state complaint investigators who I train. At the end of the day, particularly if they have attorneys, the attorneys are paid. They go back to their offices and move on to the next case. Day in and day out, more often than not, the parent and the school district must continue to face each other in order to continue to educate that child if the child continues to be eligible. I'd rather be in that situation than go through a very acrimonious, a very angry at times process like due process, and then having to face the school district or the parent the very next day. So mediation avoids all of that. So with that, I'll leave you with this, and then I'll take whatever questions, and I will stay on for, beyond, so long as include New York City can do, beyond the 7 o'clock timeline to answer all questions that you might have. With that, I have, as you've heard, sat in many capacities. I've worn many hats. I have served as a judge. I have served as a state review officer. I have served as a state complaint investigator. I have served as a parent's attorney. I have served as a school district attorney, and I have served as a mediator. In the end of the day, I wish that all hearing officers are put out of business. And I say that frankly. I hope I get put out of business, because if I get put out of business, it means that we're doing what we're supposed to be doing, which is educating children with disabilities. And of all the processes, all the roles that I've played, the most satisfying of of them is mediation. Because at the end of the day, I am helping the school district and the parent reach an agreement that comes from them. I'm helping them continue to talk with each other, and I'm preserving the relationship that needs to be preserved for the sake of the child. And so with that, Kylie, I open it up to any questions, whether you reading them or someone raising their hand and asking me a question directly.
We got quite a few that have piled up, so I will pass them along. But the first one is, I understood that most due process hearings end in settlements. Is that true?
Yes, there are many due process complaint end in settlement, depending on the what has been requested. Though the settlement, one can count it as a quote a win. Considerable amount of time has been expended for that. If it's a tuition reimbursement case, well, a parent would have to front the cost for that in many instances and perhaps wait well over a year before they see the cost. And as you might know, if you're a parent of a child with disability, some of these private schools for children with disabilities, we're not talking about $5,000. We're talking about close to $50,000 easily, and some as much as $100,000, and some as much as $250,000, depending on the need. If it's about services, the same thing. While I think our hearing officers do a very good job to try to queue those cases up to the front of the line, so to speak, so that they're not waiting, there's a lot of time expended in those cases in trying to reach that agreement. And the agreement doesn't always address what should have been done to make up for what was lost. It sometimes only deals with the perspective, what's going to happen moving forward, but they don't necessarily address the makeup services. So those are some of the issues that come up with settlement agreements, but the biggest one being the wait time, and then sometimes the failure to implement those agreements.
Great. We have a few questions along this line, but it says the IDEA mandates a resolution meeting, but is there a consequence if the DOE fails to hold to that resolution meeting?
That's a great question. IDEA, yes, there is a consequence, and it's a very logical consequence. If the school district does not hold the meeting within those 15 calendar days, the parent can petition the hearing officer to start the 45-day timeline. They don't have to wait until the 30 days expire. They can come to the hearing officer and say, hey, I was here, ready, and able. The school district has not conducted this meeting or has not scheduled a meeting within the 15 calendar days. So hearing officers start the hearing, start the 45-day time. Great question.
Great. So we have, does an attorney have to accompany a parent to the due process or mediation process? And if so, who's responsible for those fees?
So the attorney does not have to accompany the parent to a due process hearing or mediation. Many parents elect to have attorneys there because, at least in the due process hearing, it is a much more legal proceeding, and certainly mediation is not. And particularly in mediation, you have the benefit of the third party neutral. IDA says that if the parent prevails at a due process hearing, and there's no subsequent appeal of that decision, the school district says, I will accept the decision of the hearing officer, and there is an attorney involved, the parent is entitled to reimbursement for reasonable fees. And the attorney would work with the parent in filing an action, because it's another lawsuit, to try at least hint to the school district they're going to file a lawsuit, as is required in New York City. Get this a required form that they have to file before they start the lawsuit. And that will typically, if the school district does not want to challenge the fees, will then result in some negotiations between the attorney and the school district, and then the school district reimburses the parent the reasonable fees. There are no fees typically associated with mediation. That said, if the parent expended money in a mediation, and this is the provision that I was saying that's being looked at, in other parts of the country outside of New York State, the parent and their attorney can try to negotiate as part of this mediated agreement those fees, and meaning that the school district will pay them, reimburse the parent for the cost of those fees. But that cannot be done right now, as the policy in New York State is that fees cannot be included in a mediated agreement.
Great. So we have someone who asked, does New York have a deadline as to when mediators have to submit their paperwork notifying their office of the final outcome of the mediation? And if so, how much time is provided?
I don't quite understand the question because, but at least let me answer it this, and then whoever, if they raise their hand, I'm happy to hear some more about it. At the end, what in a mediated session, the parties walk out of that mediation with the actual agreement in hand. So both parties will have the agreement. For the parent, that you put it on your file, you file it away to make sure and keep it in a safe place to make sure that they do what they say they're going to do. For the school district individual who signed that agreement should then bring it to their supervisor to say, hey, this is what we agreed to and this is what we need to implement. There's no timeline in IDEA or New York State law or policy in New York State law by when that has to happen.
Great.
But let me say this, I'm sorry.
Oh yeah, no problem.
The one thing but we can fix that by when things have to happen. And the way that is fixed is, particularly with a very good mediator, of which I've met many in New York State, is you add timelines into the mediation agreement. By February 15, 2022, by 5 p.m., the school district will provide to the parent XYZ by mail or hand it to the parent, whatever it is. So you add those timelines, which makes it even a little more comforting, because then now the parent can say, hey, February 15 is coming up. By this date, I'm going to be handed something, or they're going to mail me something, and I should expect it a few days later. Sorry for that, Kylie. Go ahead.
Oh, no problem. So I'm just going to quickly launch our evaluation poll, but we'll keep going through questions. So one is, how is mediation arranged for a state complaint?
The parent or the school district will inform the state complaint investigator of their desire to mediate a state complaint, and then the investigator should put the parent and school district in touch with the appropriate CDRC to initiate the discussion as to whether both parties agree to it or not. Now, if the parent's familiar with the local CDRC that is in their neighborhood, the parent can also reach out to the CDRC and say, hey, I initiated a state complaint, or there is a state complaint that is pending that was filed by the school district, and I would like to mediate that. And then the CDRC folks would then do a little work to identify who they need to get in touch with in order to ask the school district whether they too are in agreement to mediate.
Great. I think this one is the last question. So what if there is an agreement in mediation, but the agreement was not incorporated in the IEP? What would take precedence, the mediation agreement or the IEP?
That's a great question. And New York State does require that, and the New York State law requires that if a mediation agreement if the student's IP is changed in a mediation agreement, they must the Committee on Special Education must convene the meeting to change the IEP of the student to conform it to whatever is agreed to in the mediated agreement. Now, that's what should happen. But the question kind of suggests, well, what happened if it doesn't? Which takes precedent? Well, that becomes a interpretation of if you're going to file a state complaint to enforce a mediated agreement of the complaint investigator. I will tell you that if the failure is there, even if there was a judge who was deciding this down the road, that the reasonable, what I think will reasonably happen is that someone's going to look at this and say, hey, this is a mediated agreement. The school district did not follow the what's required under the law, but it does not make the mediated agreement invalid. I will read this IEP in conjunction, side by side with the mediated agreement. That mediated agreement is enforceable, and I would suggest, and my opinion would be, that a judge, a state complaint investigator, will say that the precedence is going to be on the mediated agreement if that mediated agreement speaks specifically to a prior IEP and identifies that prior IEP. So the fact that they didn't, quote, follow the letter of the law, in my opinion, will not necessarily doom the student, the parent, or the school district, depending on who's raising the issue, because that mediated agreement is still a valid agreement and would take precedence in modifying what happened prior to that agreement being signed.
Great, and it looks like that was all of our questions. So I think we are good to go. But thank you
And
so much for answering all these and staying on a couple extra minutes.
oh, no problem. I appreciate everyone's time, and I hope that this has been helpful to you.
Yeah, awesome. Thank you and have a good night.